Good afternoon to one and all. Myself, Kaushiki Roy, Assistant Professor at IIMT College of Law. Today I am going to give a lecture on concept of bail. So now we will start from the introduction part, which is we have already seen the circumstances in which a person may be arrested under a warrant or even without a warrant. One important purpose of arrest is to secure the presence of the accused person at the time of his conviction. If the purpose can be achieved without forcing detention on the accused during the inquiry of trial, it would be an ideal blending of two apparently conflicting claims, namely freedom of the individual and the interest of justice. The provisions relating to bail aim at such blending. They have been enacted with a view to restoring liberty to the arrested person without jeoparding the objectives of arrest. In what cases bail to be taken is given under section 436 of IPC Indian Penal Code. When any person other than a person accused of a non-bailable offense is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceeding before such court to give bail, such person should be released on bail, provided that such officer or court, if he or it thinks fit, may and shall, if such person is indigent and is unable to furnish security, instead of taking bail from such person, discharge him on his executing a bond without sureties for his appearance as hereinafter provided. Explanation: where a person is unable to give bail within a week of the date of his arrest, it shall be a sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this proviso. Provided further that nothing in this section shall be deemed to affect the provisions of the subsection 3 of section 116 or section 446A. Now, maximum period for which an under trial prisoner can be detained is dealt under section 436A is that where a person has during the period of investigation, inquiry or trial under this code of an offense under any law undergone detention for a period exceeding up to one half of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court of on his personal bond with or without sureties, provided that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a period longer than one half of the said period, or release him on bail instead of the personal bond with or without sureties, provided further that no such person shall in any case be detained during the period of investigation, inquiry, or trial for more than the maximum period of imprisonment provided for the said offense under that law. When bail may be taken in case of non-bailable offense under section 437. When any person accused of or suspected of the commission of any non-bailable offense is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court other than the High Court or Court of Session, he may be released on bail, but such persons shall not be so released if there appear reasonable grounds for believing that he has been guilty of an offence punishable with death or imprisonment for life. Such person shall not be so released if such offence is a cognizable offence and he had been previously convicted of an offence punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted on two or more occasions of a cognizable offence, punishable with imprisonment for 3 years or more, but not less than 7 years. Provided also that the mere fact that an accused person may be required for being identified by witnesses during investigation shall not be sufficient ground for refusing to grant bail. If he is otherwise entitled to be released on bail and gives an undertaking that the shall comply with such directions as may be given by the court. Any court which has released a person on bail under subsection 1 or subsection 2 may, if it considers it necessary so to do, direct that such person be arrested and commit him to custody. If in any case triable by a magistrate, the trial of a person accused of an non-bailable offence is not concluded within a period of 60 days from the first date fixed for taking evidence in the case. Such person shall, if he is in the custody during the whole of the said period, be released on bail to the satisfaction of the magistrate, unless for reasons to be recorded in writing, the magistrate otherwise directs. If at any time after the conclusion of the trial of a person accused of a non-bailable offence and before judgment is delivered, the court is of opinion that there are reasonable grounds for believing that the accused is not guilty of an offence. It shall release the accused if he is in custody on the execution by him of a bond without sureties for his appearance to hear judgment delivered. Now, certain case laws. Gachanan Agrawal versus State of Odisha, Chandraswamy versus Central Bureau of Investigation 1997, Afzal Khan versus State of Gujarat 2007, State of Maharashtra versus Ramesh Taurani 1998. Now we will discuss about section 437A of Indian Penal Code. Bail to require accused to appear before next appellate court. First, before conclusion of the trial and before disposal of the appeal, the court trying the offence of the appellate court, as the case may be, shall require the accused to execute bail bonds with sureties to appear before the higher court as and when such court issues notice in respect of any appeal or petition filed by filed against the judgment of the respective court. When such court issues notice in respect of any appeal or petition filed against the judgment of the respective court, and such bail bonds shall be in force for 6 months. Second, if such accused fails to appear, the bond stand forfeited and the procedure under section 446 shall apply. Now we will discuss about the direction for grant of bail to person apprehending arrest. This topic deals under section 438 of Indian Penal Code. So, where any person has reason to believe that he may be arrested on accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Session for a direction under this section that in the event of such arrest, he shall be released on bail, and that court may, after taking into consideration inter alia the following factors, namely: first, the nature and gravity of the accusations; second, the antecedents of the applicant, including the fact as to whether he has previously undergone imprisonment on conviction by a court in respect of any cognizable offence; third, the possibility of the applicant to flee from justice; fourth, where the accusation has been made with the object of injuring or and the humiliating applicant by having him so arrested, either reject the application forthwith or issue an interim order for the grant of anticipatory bail. Next, provided that where the High Court, or as the case may be, the Court of Session, has not passed any interim order under this subsection or has rejected the application for grant of anticipatory bail, it shall be open to an officer in charge of a police station to arrest without warrant the applicant on the basis of the accusation apprehended in such application. More case laws. State versus Anil Sharma 1997, Sajjan Kumar versus State 1991, Savitri Agarwal versus State of Maharashtra and another 2009. Now we will discuss about the special powers of High Court or Court of Session regarding bail. This topic deals under section 439 of Indian Penal Code. A High Court or Court of Session may direct that any person accused of an offence and in custody be released on bail, and if the offence is of the nature specified in subsection 3 of section 437, may impose any condition which it considers necessary for the purpose mentioned in that subsection; that any condition imposed by a magistrate when releasing any person on bail be set aside or modified; provided that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence which is triable exclusively by the Court of Session, or which, though not so triable, is punishable with imprisonment for life, give notice of the application for bail to the public prosecutor, unless it is for reasons to be recorded in writing of opinion that it is not practicable to give such notice; provided further that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence triable under subsection 3 of section 376 or section 376 or section 376DA or section 376DB of the Indian Penal Code, give notice of the application for bail to the public prosecutor within a period of 15 days from the date of a receipt of the notice of such application. More case laws. PC Chandak versus State of Odisha, 1993. Himanshu Chandravan Desai versus State of Gujarat, 2006. State versus Mohinder Singh, 1994. State of Uttar Pradesh versus Anup Kumar, 1994. Section 440 and Section 441. Section 440 discuss about the amount of bond and reduction thereof. The amount of every bond executed under this chapter shall be fixed with due regard to the circumstances of the case and shall not be excessive. The High Court or Court of Session may direct that the bail required by a police officer or magistrate be reduced. Section 441, Bond of accused and sureties. Before any person is released on bail on or released on his own bond, a bond for such sum of money as a police officer or court, as the case may be, think sufficient, shall be executed by such person, and when he is released on bail by one or more sufficient sureties, conditioned that such persons shall attend at the time and place mentioned in the bond, and shall continue so to attend until otherwise directed by the police officer or court, as the case may be. Where any condition is imposed for the release of any person on bail, the bond shall also contain that condition. Section 441A and Section 442. Section 441A discuss about the declaration by sureties. Every person standing surety to an accused person for his release on bail shall make a declaration before the court as to the number of persons to whom he has stood surety, including the accused, giving therein all the relevant particulars. Section 442, Discharge from custody. As soon as the bond has been executed, the person for whose appearance has been executed shall be released, and when he is in the jail, the court admitting him to bail shall issue an order of release to the officer in charge of the jail, and such officer on receipt of the orders shall release him. Section 443 and 444. Section 443 discuss about the power to order sufficient bail when that first taken is insufficient. If through mistake, fraud, or otherwise insufficient sureties have been accepted, or if they afterwards become insufficient, the court may issue a warrant of arrest directing that the person released on bail be brought before it, and may order him to find sufficient sureties, and on his failing to do so, may commit him to jail. Section 444, Discharge of sureties. All or any sureties for the attendance and appearance of a person released on bail may at any time apply to a magistrate to discharge the bond, either wholly or so far as relates to the applicants. On such application being made, the magistrate shall issue his warrant of the arrest directing that the person so released be brought before him. Now we will discuss about section 445 and 446. Section 445, deposit instead of recognition. When any person is required by any court or officer to execute a bond with or without sureties, such court or officer may, except in the case of a bond for good behavior, permit him to deposit a sum of money or government promissory notes to such amount as the court of officer may, if in lieu of executing such bond. Section 446, procedure when bond has been forfeited. Where a bond under this code is for appearance or for production of property before a court and it is proved to the satisfaction of that court or any court to which the case has subsequently been transferred that the bond has been forfeited, or where in respect of any other bond under this code it is proved to the satisfaction of the court by which the bond was taken or of any court to which the case has subsequently been transferred, or of the court of any magistrate of the first class that the bond has been forfeited. Explanation: a condition in a bond for appearance or for production of property before a court shall be constructed as including a condition for appearance or, as the case may be, for production of property before any court to which the case may subsequently be transferred. Insufficient cause is not shown and the penalty is not paid, the court may proceed to recover the same as if such penalty were a fine imposed by it under this code, provided that where such penalty is not paid and cannot be recovered in the manner aforesaid, the person so bound is as surety shall be liable by order of the court ordering the recovery of the penalty, the imprisonment in civil jail for a term which may extend to 6 months. The court may, after recording its reasons for doing so, remit any portion of the penalty mentioned and enforce payment in part only. When a servitor to a bond dies before the bond is forfeited, his estate shall be discharged from all liability in respect of the bond. So thank you. I hope this lecture will help out the students of third year. Okay, thank you.